Good morning, counsel.
Good morning, Your Honor. May it please the Court, Richard Goldman for the defendant, Mr. Hoyt, on appeal of his convictions out of Berkshire Superior Court. Two main issues were raised in the brief. I'd like to address the admissibility of the defendant's statement, if I might. This Court should rule in the defendant's favor and reverse his convictions for three reasons. First, the statement, Mr. Hoyt's statement was wrongly admitted into evidence because he never waived his right to counsel. And this Court should conclude that based on state and federal law. And the error was not harmless. Second, the motion judge erred in concluding that Mr. Hoyt was required to make an unambiguous or unequivocal assertion of his right to counsel. That's not the applicable standard in this case, and this Court can find that under state and federal law as well, and that error was not harmless. And third, under Article 12, under state law, state constitutional law, the statement was wrongly admitted into evidence. And this Court can find, based on the broader protections afforded to citizens of the Commonwealth under Article 12, that the statement was wrongly admitted and was not harmless, and the conviction should be reversed.
Well, would you concede that if this had been post-waiver, in other words, he'd waived his Miranda rights and his right to remain silent and all of the rights that are listed therein, and had been speaking to the police and then said something to the effect, I think I should have a lawyer, something that was ambiguous, do the police have to clarify that? I mean, would you concede they don't have to clarify that unless it's unambiguous?
Well,
they don't have to stop unless it's unambiguous?
Right, but your question poses the critical difference of when the assertion or the request for counsel is made.
So why is it different if it's pre-waiver? Same ambiguous statement. If it's post-waiver, police don't have to stop questioning. If it's pre-waiver, what do they have to do?
Well, partly I think there's a tension between police giving rights to when is a defendant or a suspect entitled to counsel? The initial Miranda warnings are designed to tell people what their rights are. They have to understand them. They have to validly waive those rights. They have the opportunity at that point to request counsel or to decide to speak. Once they make that, and the cases say it has to be voluntary, knowing, if we get to the waiver issue, but that's different, a different situation. And the police what's the interest of the police at that point? They're trying to get a statement, and a suspect is sitting there being interrogated. They have to make that initial choice of what they're going to do.
So on these facts, when did the defendant communicate to the police that he wanted to invoke his right to counsel?
In this case, it was about 3 minutes and 20 seconds into the interview. He was
how did he do that?
He was the testimony at the hearing was that he was arrested on I believe it was a Thursday, but a weekday afternoon. He was given one of the detectives testified at the hearing, and it's established in the transcript of the interrogation. He was given his Miranda rights warnings at the time of arrest. He was taken to the police station. He was booked. He was given Miranda rights again. Then shortly thereafter, he was taken to an interview room, given Miranda again. So the interview starts. It's on tape. It's video. The court has it. So he was given his Miranda rights at the start of the interview. After being read his rights, one of the detectives said, "This right here states you understand everything I just read to you." He's talking about the Miranda waiver. "Having these rights in mind, do you wish to speak to us now? You don't want an attorney." The defendant said, "I'd like an attorney present. But I can't afford one, so I guess I'll speak to you now. I don't have an attorney." At that point, under Miranda, Edwards, Smith versus Illinois, under federal law, the interview should have stopped, because those cases talk about, Miranda and Edwards talk about a clear assertion, a clear statement indicating a desire for counsel.
So you're saying it was not unambiguous. It's not
Correct.
Unambiguous here, so we
Correct.
don't even have to worry about that.
Correct. In the first level, it's not ambiguous. It's a clear statement requesting counsel. So I guess I'll speak to you now. I'll speak to you now. What's ambiguous, perhaps, is whether he understands the Miranda warnings. So first say, I guess, is that yes, interrogation should have stopped at that point. But if anything came after that, it should not have been the next statement, which was from the detective who said, If you want to speak to us later, that's fine as well. Because that's not the choice at that point. The choice isn't, you talk to us now, you talk to us later. And it's just, and because someone doesn't have an attorney and doesn't know the process of how they go about getting an attorney when they're brought into an interrogation room, but they clearly express, I'd like an attorney present.
Now, am I correct that the defendant was not arrested immediately after the incident itself? There was a lapse of time of several weeks between the incident on this, wasn't it, or is that not true?
Well, the evidence at trial was that the allegations were that this conduct occurred over a period of years.
Okay.
It wasn't it wasn't correct. It was a period of time.
Help me with what, you say the standard pre-waiver should not be unambiguous and unequivocal, but you say it must be clear enough for the government to know he's invoked his right to counsel and I must cease questioning. What do you say is the standard?
Well, that under Miranda and Edwards and Smith versus Illinois, those cases talk about, in Edwards, whether the accused expressed his desire or clearly asserted his right to the assistance of counsel. In Miranda, it says whether the accused indicated in any manner and at any stage of the process that he wished to consult with an attorney before speaking. That's different from when the United States Supreme Court gets to Davis and more recently Tompkins, which are post-waiver cases. That's when they insert the unambiguous, unequivocal language.
Tompkins isn't a post-waiver.
Tompkins is pre-waiver.
Well, Tompkins. What happened? The suspect was silent for 2.5.
But he'd never signed a waiver.
He never signed a waiver, and he was silent for almost 3 hours.
That was the issue, whether it was or wasn't.
Right. And I think what the Supreme Court did in that case is they decided that they extended their holding in Davis, where they said that a defendant had to clearly and unambiguously assert the right to counsel. They said there's no real distinction between that and the right to silence, so we're going to extend that to the right to silence.
How do you get a clear statement unless it's clear and not ambiguous? I mean, it's kind of circular. I mean, it has to be clear, and so thus not ambiguous.
Right. I think that the way the cases have interpreted it, that's those two standards. Admittedly, it might be a fine line, but I think there's a higher burden of proof. It places a higher burden on a suspect. I'm sorry.
No, finish.
To establish that their statement is unambiguous, rather than just the sense that, again, Miranda, Edwards, Smith versus Illinois. Maybe, in part, as this court has recognized, the United States Supreme Court has pulled back in their decisions from the protections initially afforded to suspects under Miranda.
Can I go ahead?
No, you go ahead.
Can I ask you this? Is part of your argument here, is part of the sort of context here, is that Massachusetts requires that waivers be proved beyond a reasonable doubt, and the federal courts only require under the U.S. Constitution that they be proved by a preponderance of the evidence? Is that part of why we should consider this statement, which is clearly which is clear and ambiguous at the same time, why we should consider it differently than the federal courts might consider it?
Yes, and also in addition to that, because Article 12, as this court has stated on numerous occasions, provides broader protection to citizens of the Commonwealth in the area of the right against self-incrimination than the federal Constitution does, and the United States Supreme Court has interpreted the Fifth Amendment.
So what should have happened here? You're the police officer. The suspect says, I'd like an attorney present, but I can't afford one, so I'll speak to you now. What is the officer supposed to do? Okay, fine.
I think that's it.
Okay, fine, let's talk. What is he supposed to do?
Okay, fine, we're done. But because the statement of this court has expressed it, in a number of cases, again, in last year in Morganti, that when a suspect merely muses about, I think maybe I need a lawyer, maybe I should get a lawyer, those kinds of statements where it's a conditional thought of the defendant being expressed.
Well, should the officer then say, well, as I just explained to you, if you cannot afford an attorney will be appointed for you? Should the officer go back and then sort of repeat that right or that protection?
If anything, that's what should happen, yes. That it shouldn't be, okay, you could talk to us now, or you could talk to us later. Oh, I'm sorry, I didn't say that. I mean, you could talk to us later. It should be, yes, if anything, and first I would say it should be nothing, but if anything, it should be, again, making sure that the suspect understands what his or her choices and rights are at that point in time.
What about what about the fact that the police officer said, here's a phone book? You can get a lawyer.
Mm-hmm. Right. In the context of this case, the defendant, I think a suspect doesn't know, I don't have it. When someone says, I can't afford an attorney, I don't have an attorney, I can't afford an attorney. At that point, I don't even think it should, well, I submit it shouldn't have got to that point where here's a phone book. But still, the phone book doesn't, giving someone a phone book when they don't understand what their rights are going to be in the first instance about how they're going to go about getting an attorney if they can't afford one. That's part of the problem with continuing the interrogation after or interview after someone clearly makes an assertion to the right to counsel, because the police can then do, because they're looking, I mean, they're there to get a statement. So what they say, here's a phone book, presenting a choice to a suspect who may not have experience with being interrogated before with the criminal justice system, and then at that point they're faced with a decision. What am I supposed to do with the phone book?
What if you had a situation where he says, I'd like to have an attorney present, but I can't afford one, and they say to him, yeah, well, we just told you, the state will apply it. We can't tell you, you have to, here's the phone book, we can't do it, but we told you the state has to supply it if you can't afford it. And they start to walk out the room, and he says, no, I want to talk to you now. Are they supposed to have stopped? Should they just keep walking?
I think in your hypothetical, if they say, if you can't afford one, the state, if they make that clear.
Well, they have said that to him.
In the Miranda rights, which he has already expressed, that he's already said, I want an attorney. So, that's his first response after he gets Miranda, I'd like an attorney present. If they then, again, I think they should stop at that point. But if they continue to speak, if anything, then yes, they should be explaining to him somehow in a non-persuasive, non-coercive manner what his rights are to how he might go about obtaining an attorney. That might be acceptable. But
aren't there really two issues here? One is whether or not the statement was clear enough as to cause the Commonwealth to stop questioning. And then separate and related to that is whether or not there was a waiver, a knowing and informed waiver beyond a reasonable doubt. Aren't those two actually distinct questions here?
yes, they are. And also related to that is the standard on how to assess what the statement was, which gets to the clear statement or unambiguous, which the motion judge, when the motion judge applied the unambiguous and unequivocal standard to that, that was incorrect.
Did the judge make any findings as to waiver?
It was a motion hearing, and the judge made oral findings, spoke from the bench. I don't recall specifically. I think it's implicit in his ruling, but I'm not sure.
Do we have a copy of the Miranda waiver form? I didn't see it in the record.
Oh, I'm not sure of that, but I believe he did sign.
Well,
but I
the
don't
video
know.
shows him signing it at various points. And that he didn't have his glasses to
Right.
read it, and
But then he
they
said
were,
he could read. He said he could read it along.
and he was signing in various places.
Mm-hmm.
It wasn't just like one signature.
And I think he signed before. I believe he signed before the statement. I'd like an attorney present. I think he signed the video. It
was the video, whether or not it was going to be recorded, and there were a series of questions. And I just wondered if we had the form.
I don't think I included it, but we could certainly provide it to the court. But I think he did sign. I think it shows that he did sign before he made the request for counsel. Before he made the statement, I'd like an attorney present.
Mm-hmm.
And I think, though, I think it is a sort of a complex issue on how it does tie in with the standards to be applied and how to evaluate the initial waiver. I see my time is up. If there are no further questions, I thank the court for consideration.
Good morning, Your Honors. Karen Carlo for the Commonwealth. Your Honors, it's the Commonwealth's contention that the defendant's statement that he would like an attorney present but couldn't afford one, so he would just speak to them now, was an ambiguous statement, and that the police officers in this case actually followed what this court has deemed to be the best practice and attempted to clarify what the defendant was stating, even though there is no requirement under the law that they do so.
Did they really?
Well, there's nothing ambiguous about I'd like to have a lawyer here.
But I can't afford one, so I will speak to you now. I think that's an ambiguous statement.
Well, but
But
it's a
I can't
misunderstanding.
afford one.
Yeah,
That
it's-
obviously he didn't understand, right?
Right, but the defendant stated that he understand his Miranda rights, and he was read his Miranda rights 3 different times, in which they stated if you cannot afford an attorney, one will be presented for you. There is,
But isn't it kind of misleading then to say, here's a phone book? I mean, that's not how you get a lawyer if you can't afford one. That's how you get a lawyer if you can afford one.
right,
And they didn't explain how you'd get a lawyer appointed for you. They only talked about, and they gave them that phone book a couple times, or offered the phone book,
Right.
which was just about paid attorneys
Right.
and saying, we don't get you an attorney. And isn't that not, isn't that kind of misleading?
well, correct me if I'm wrong, Your Honor, but I'm not aware of any law that states that the police have to inform the defendant that he will not be provided an attorney until the...
No, I'm not going there. You're saying that all this was to clarify.
Mm-hmm.
And I'm wondering if it really clarifies anything about when somebody said to you, I can't afford a lawyer, I'd like a lawyer, I can't afford a lawyer, to
Right.
hand him a phone book.
Right. I think in this case, the police made their best efforts to clarify, and perhaps, their actions weren't perfect.
Their best efforts to clarify, he says, I'd have to wait here until an attorney came in, suggesting that he's going to sit in that room until somehow he can find an attorney, which he can't afford. How
Well,
doesn't that suggest that he's going to sit there until he can find an attorney that he says he can't afford? How is that clarifying?
Your Honor, when analyzing whether a request for counsel is ambiguous, the court needs to look at the circumstances before and after the ambiguous request, whether it's ambiguous or not. And I think what occurred after his so-called ambiguous request for counsel is that you could see from the conversation that he had that his main concern was having to wait before he spoke, having to wait to get an attorney before he spoke with them. And our interpretation of the conversation is that he doesn't want to wait for an attorney, whether it's provided to him or not. He just wants to speak to them.
But isn't it really, though, in the context, he doesn't want to wait, but it's presented in a way that he has no idea whether he's going to be able to get an attorney. I mean, he gets a phone book. I don't know whether it's the white pages or the yellow pages. I mean, it seems daunting, doesn't it?
Well, we're not conceding the point that the police, their actions misled him into thinking that.
In no way suggesting they meant to. I think they were trying, there's nothing, no suggestion that they were doing anything than trying to explain things. It's just a question of objectively, how was he supposed to deal in this situation, I think, or did it clarify the ambiguity?
And I think that's a finding for the motion judge to make, and he found in this case that the defendant made an ambiguous statement and that the police did not have to stop questioning them.
I didn't see that the motion judge found beyond a reasonable doubt that his waiver was voluntary, knowing, and intelligent. It seemed to me the motion just says, well, it's not unambiguous, therefore it's not an assertion of the right to counsel. I didn't see any finding of waiver.
Your Honor, I don't believe there is a specific finding. I think it was just implied.
Because the key thing here is that the Commonwealth has to prove beyond a reasonable doubt that there is a knowing, voluntary, intelligent waiver. And how can you prove that when the person says, I would like a lawyer present, but I can't afford one? And that clearly represents, so I guess I'll talk to you now. It clearly represents a misunderstanding of the right. So how can you say
I think it can be clarified by looking at the remainder of the conversation, in which the defendant states, I'll just talk to you without an attorney, and Sergeant
because here's a phone book, and, you know, it's up to you. Go ahead, find one. Well, how do I, essentially, do I have to wait? How do I find one? Well, I'll just go ahead and talk to you. I mean, how does that sort of display the kind of voluntary, intelligent, knowing waiver that we say has to be proved beyond a reasonable doubt?
The defendant also could have invoked his right to remain silent in this case, and he didn't.
Well, that right is the reason why you have right to counsel is not because of any Sixth Amendment right to counsel, but it's to assure that if you assert your right, or you're asked to assert your right, whether you want to remain silent or not, you can ask counsel about that. I mean, that's to protect that right. The right to counsel is to protect the right to remain silent. So if you don't understand that you have a right to an appointed counsel that can be provided for you, then how can you say, well, he voluntarily waived his right to silence?
I think we can't say for sure that the defendant did not understand his rights in this situation.
But don't you have to say that?
Well,
That's the burden.
I think the burden is, yes, that the defendant knowingly and voluntarily waived Miranda. But at the end of this exchange, Detective Easton says, so having these rights in mind, you wish to speak with us now, and that is the right to remain silent and the right to an attorney. Again, I think there's no requirement that the police have to inform the defendant that they will receive an attorney appointed to them. You know.
Well,
What's
this
the
is after.
significance?
Oh, I'm sorry. Go ahead.
What do you say the significance of his statement that I can't afford a lawyer, but I can't afford a lawyer? What did that mean? Other than, because I understand that I have to pay for my own lawyer. Mm-hmm. Is there any other way to interpret that?
If he had just said, I'd like an attorney present, but I can't afford one, I think that should have ended the discussion right there.
And that's because it indicates that his understanding was that I have to pay for my own lawyer.
And he says, but I guess I'll speak to you now. That could be interpreted as,
But what you're saying
Well,
is that
well,
makes it ambiguous.
Well, it could be,
yeah, it
but,
makes it ambiguous.
but it makes it ambiguous.
Right.
So why don't they say the whole thing, you have a right to speak to, or what, if you can't afford one, will be provided for you? I mean, where's the rest of it? The one that he's unclear about, I think, is the thrust of the question.
Right. But he stated,
Why only part of it?
pardon me?
They don't clarify. That's the way to clarify the ambiguity. I can't afford one, right?
I think,
Shouldn't that be the rule? So
think,
clarify where the ambiguity arises, which arises from a misunderstanding clear from the statement, rendering it ambiguous. I can't afford one. He doesn't know he can be provided one. I'm not saying they should go get him one, but at least the statement, one can be provided for you.
they could have done that, but a clarification is not required in these situations where it's ambiguous.
But can you give only part of a clarification? I mean, what they're saying is, I mean, we're not, we don't get you an attorney, we can let you use a phone book and stuff like that, but it's up to you. And they says, oh, I'll just talk to you now. Okay. Roy, I just want to make it clear you want to talk to us now and you don't want an attorney. I'd have to wait here until an attorney came in, right? We can let you use the phone and the phone book to call an attorney. I can't tell you that they'll come here. I don't know what they would do. And then he says, I'll just talk to you without an attorney. At no point is the alternative about appointed counsel clarified.
Correct.
And so it's not really a full clarification after he's already expressed the fact that he can't afford an attorney. So the one alternative that he has is not being explained to him.
That is correct, and but I think that's why clarifications in these circumstances are not required, because in this case, the police have attempted to clarify, and now it's being analyzed and suggested that their clarification wasn't good enough, and
But I guess what's different about this than another ambiguous case is I actually think his statement isn't ambiguous. What it shows is a clear misunderstanding, that he didn't hear the part about how he didn't need, that if he couldn't afford one, that the Commonwealth would supply a lawyer. So he's operating, I think it's pretty clear from his first statement, reading it all together, he's operating under the premise that he's going to have to pay for a lawyer. And that's what, so that in a way isn't ambiguous. It's just a misunderstanding, and that never gets clarified.
right. But I think
So it's hard to call it, this is a case where it's ambiguous. I guess I come away thinking it isn't. It's just he doesn't get it.
Well, I think we have to put ourselves in the shoes of a reasonable police officer when addressing their actions in this case. And a reasonable police officer could understand, so I guess I'll just speak to you now, I don't have an attorney, as waiving his right to counsel.
Let me ask you a question. When the judge had the hearing, was it an evidentiary hearing? I mean, did the judge have anything in front of him other than the videotape of the, and of course, I presume the Miranda waiver form itself? I mean, did he hear the testimony of the police officers?
No, I believe he analyzed the video in this case.
So it's the same video we have?
Yes, it is, Your Honor.
So we're in the same position as the motion judge?
Yes, you are, Your Honor.
And are you aware of whether we have a copy of that in the Miranda form that he signed in the record?
I don't think you do, and so we can provide that if that's what this court would like us to do.
One question, the tape recording, one-party consent illegal, I assume? The tape recording made of the defendant by the mother before they went to the police?
Your Honor, I don't think that issue was raised by the defendant in this case, but I think...
But I guess my question is, how is it admissible?
I
mean, it's an illegal tape recording, isn't it?
I think it's admissible because the police were involved in the recording. I'm not aware of any law that states illegal recordings not made by the police are not admissible, particularly if there's no objection at trial.
Chapter 272, Section 99?
Okay. But I don't think that issue was raised
So
prior.
you're saying it was waived?
Yes, Your Honor. If there are no other questions, we rest on our brief.
Thank you.
Thank you.